we've got quite a lot to get through in this talk, so I'm going to have to breeze through it because the presentation is slightly longer than the limited slot I've got to talk to you all. I'm going to speak to you about placing looked after children in foster care and institutional care outside of England and Wales. Now, broadly speaking, the circumstances around such placements either involve placements in institutional care or foster care in another country, usually another EU member state within the context of care proceedings, or placement of children, usually elder children, in residential settings in Scotland. In my experience, those are the majority of situations you find in which a child is being placed outside of the jurisdiction, usually with a non-family member. What I'm going to do is set out the basic legal provisions and go on a whirlwind tour around them. You will be aware, following Brexit, that Brussels II Revised, which was the main jurisdictional framework that applied to cases involving parental responsibility, no longer applies to proceedings that are instigated after Brexit Day. If there are care proceedings or private law proceedings issued before Brexit Day, Brussels II still applies. Article 56 provides, within Brussels II Revised, for the placement of a child in institutional or foster care in another jurisdiction. Article 56 is set out in full there. It's essential that you have a full and detailed grasp of Article 56 and its remit. The leading authority in Article 56 remains the Health Service Executive versus SC and AC, but also have a read the COBJ decision, ReLM, which relates to Article 15 transfers of care proceedings between Ireland and England, but also deals with the Article 56 mechanism and how you move a child from foster care in one country to another country. Article 56 does require consultation with the central authority of the member state in question. That's done via ICARCU, and the consent of the member state needs to be obtained before the English court approves placement of a child in institutional or foster care in that state. However, given the fact that the UK has now exited the EU, the question is, well, how can moves of children in this country to institutional and foster care abroad be facilitated if Brussels II doesn't apply? And the answer is that the Hague Convention 1996, not to be confused with the 1980 Abduction Convention, applies. That provides a jurisdictional framework that mirrors many of the conditions, broadly speaking, in relation to Brussels II Revised. And you also find that, in general, the majority of European states are signatory to the Hague Convention 1996. That's a convention on child protection measures, so I'm going to call it the Protection Convention. Article 33 of the Protection Convention is very similar to Article 56, set out there, and Article 33 will apply if you're seeking to move a child to institutional or foster care abroad. That is, to a state that is a member state for the purposes of the 1996 Convention. There are some broad similarities and differences between Articles 56 and Article 33. ICARCU will continue to be the main central authority in England for the purposes of the Hague Convention 1996. Main difference, and this is notable, is under Article 33, the requesting state must transmit a report on the child together with the reasons for the proposed placement. And you'd suspect that could take the form of local authorities' assessment evidence and also possibly any court judgments or reasons for advocating placement abroad. The provision of a report isn't a necessity under Article 56. Also under Article 33, consent of the relevant foreign authorities is required for all placements. So it doesn't matter if it's intended that there is continuing public authority intervention following placement, because that is a distinction within Article 56, and consent isn't required if it's not intended that there's going to be ongoing public authority involvement post-placement. You've also got the point that if a state refuses to or fails to comply with the provisions of Article 56, that's a mandatory ground for non-recognition by a foreign state of recognition enforcement of any placement. Whereas non-compliance with Article 33 gives a discretion to refuse recognition and enforcement. Convention also specifies the age range that it applies to, whereas Brussels II leaves that open to the courts in the member states in question. And there's no real existing volume of case law in relation to Article 33, because quite simply, we've only very recently exited the EU. It is notable that if you're ever involved in care proceedings in Wales, Wales has a different central authority for the purposes of the Hague Protection Convention, so you don't go via ICACU. There's also regulatory requirements instilled via the 2010 regulations that make the provisions of a report in relation to the child mandatory. As is the case with Article 56, there's some uncertainty as to whether Article 33 applies to placement with a family member. The Convention Handbook does set out some provisions in that respect, and I'm not going to quote them in detail due to the limited time we have. That, in essence, finalises everything I want to go through in relation to Article 33 and Article 56. So I'm going to go and move on and speak to you about placements of children in residential care in Scotland, in particular non-secure residential placements. This issue has been raised by McDonald J. Recently in the Salford case, and more recently in Re H. Re H is a Cobb J decision that deals with placement of a looked after child in Scotland. Importantly, the child in that case, H, was placed there on a temporary basis. I say importantly because Cobb J found that paragraph 19 of Schedule 2, which relates to arrangements to assist children in living abroad, didn't apply as the placement was temporary in nature. Cobb J was satisfied that the local authority could properly rely on the provisions of Section 37, subsection 7 and 8 of the Children Act in order to place a child subject to an interim care order anywhere in the UK, albeit the court would need to scrutinise the care plan given the fact that the child is subject to an interim care order. So, although a local authority is entitled to place a child anywhere in the UK by virtue of the sections, it does have, in my view, have to obtain the agreement of the court to that, given the fact that the child is subject to an interim care order, and any placement outside of England and Wales should be sanctioned by the court. It's essential that any placing authority moving a child to live in Scotland, I say live, to a residential placement on a temporary basis in Scotland complies fully with the 2010 regulations. A looked after child who is not subject to an interim care order can be lawfully placed in Scotland on a temporary basis, provided the regulatory process is followed correctly. And Cobb J, I've set out in the relevant part of the judgment, refers to that expressly within the judgment. Therefore, a local authority can place looked after child in Scotland on a temporary basis under Section 20, with Section 20 consent, provided the appropriate provisions of the 2010 Care Planning, Placement and Case Review regulations are satisfied. If the local authority intends to make arrangements for the child to live abroad, and I say live because that is a long-term or permanent placement, if the local authority is intending for a child to live in Scotland, there's an obligation on the local authority to obtain the court's approval under Schedule 2, paragraph 19. In cases involving long-term permanent arrangements, Re C makes it clear that the child's consent is required. And in the absence of a child's consent, one would query as to whether such a placement is feasible. An interim care order isn't recognisable or enforceable in Scotland. Therefore, a care order, whilst it can be transferred to Scotland and recognised as a compulsory supervision order under the transfer provisions, that's not the case in relation to an ICO. So an ICO has no application or recognition in Scotland. COBJ noted that it appeared possible as a matter of law for a child's parents to actually open litigation in Scotland in relation to any child placed there under an interim care order on the basis the ICO isn't recognised. Any English authority seeking for recognition or enforcement of an ICO, if that's possible, would need to consider petitioning to the noble officium of the inner houses of the Court of Sessions. And those of you familiar with the X and Y judgment will be aware that's what happened in relation to secure accommodation prior to the amendments to the legislation in that respect. COBJ didn't find that H in this case was deprived of his liberty. However, if he was being, the local authority would have again needed to consider petitioning to the noble officium, the inner house, in order to approve or in order to obtain provision for H's deprivation of liberty in Scotland to be lawfully recognised. And that can be done, and there's reference to that in the Salford case, albeit I'm not concentrating on Dole's provisions in this case. The court concluded by noting concerns in relation to the regularity with which children are being placed in unregulated placements due to a lack of adequate provisions in England and Wales. So they move over to Scotland because there's an absence of appropriate residential placements in England. It's notable that any Scottish placement wouldn't be approved pursuant to the English regulatory framework, clearly because it's not in England, and therefore in that respect it's going to be to an extent unregulated within the context of the English regulations. Any local authority placing a child in any unregulated placement does need to carefully follow the President's guidance in relation to unregulated placements. That can be obtained reasonably easy online. And in respect of any placement of a child who is looked after pursuant to Section 20 or alternatively subject to an interim care order, local authorities are strongly advised to obtain early legal advice prior to effecting any placement of a child in a residential unit in Scotland.